in denying compensability under the 120-day notice limitation provision of Section 112.18 in an otherwise compensable case where a claim for benefits was made within 180 days. Now recall that the limitation provision we're speaking of was put into the statute in 2010. This is the Heart-Lung statute. And it says that a claim for benefits must be made prior to or within 180 days of leaving employment. This case turned on the statutory construction of the phrase claim for benefits. With this phrase, what the judge held was that this phrase requires, or that the statutory provision requires, that a claim for benefits be made prior to or within 180 days after leaving employment. It is undisputed that the claimant did not file a petition for benefits within this time period. Even if the statute were construed to include activities other than filing a petition for benefits, there's no evidence the claimant took any action that may be construed as a claim for workers' comp benefits prior to or within 180 days of leaving employment. That's the judge's holding. So what the judge held was that this phrase claim for benefits was limited to the filing of a petition for benefits or some other claim for workers' compensation benefits. And what the claimant argued at trial and what we're arguing today is that a claim for benefits is more broad than that limited holding of the JCC. And I would direct the court, first of all, to the Scherer versus Volusia County case.
But the heart fluttering was in 2011.
I'm sorry, you said the heart attack?
The heart fluttering.
The heart event, yes, the
was in
arrhythmia.
2011.
Yes.
And then after he had retired, in 2016, he was at a FOP meeting and they said, hey, you need to go get some benefits.
Yes, so that's when he found out about the heart-lung statute. This is where it gets a little confusing in this case, and the claimant even admitted he was confused. Lieutenant Barfield, Nurse Shaw, and even the adjuster all talked about how there's this other heart benefit that this employer offered, and they confusingly referred to it as the heart bill benefit, and it was under the collective bargaining agreement. So what happened in this case was that the claimant in 2011, right when the heart event happened, the cardiomyopathy, the arrhythmia happened during his wellness exam that was provided by the employer back in 2011. So immediately they knew about it. And then immediately he reported it to his lieutenant, who testified at trial, and her evidence was accepted as competent substantial evidence by the JCC, that he reported it to her at that time. He was actually paid 3 weeks of lost wages under that heart benefit of the collective bargaining agreement. But a notice of injury was never filed. It was never sent to risk management. The adjuster, Ms. Stafford, testified at trial that someone dropped the ball, that a notice of injury should have been filed at that time. It should have been sent to risk management. Never happened.
Well, aren't you equating the notice of the incident, which clearly the employer, somebody in his chain of command had noticed that he had this AFib, with a claim for benefits? Or are you saying that those are the same thing?
No, not exactly, because it's more than just notice here. He was actually paid lost wages under the heart benefit. So what we're saying is that a claim for benefits is more than the judge held that a claim for benefits is only the filing of a petition or the filing of a work comp claim. We can see that neither of those happened here. He didn't file a comp claim, he didn't file a petition for benefits, but he did notify his employer and he was paid heart leave. And it was called heart leave. It's in the attendance logs. Nurse Shaw, who is the occupational health nurse charged with administering this benefit, testified that he was paid 3 weeks of benefits, and so did the claimant.
Would a claim for some other kind of benefits that the employer would have been on notice of trigger the toll the 180 days? For instance, somebody lost work, so they file a claim for unemployment benefits. Would that be a claim for benefits under the statute?
I don't think so. I don't think that would be, because the distinction here is that this was specifically a heart bill benefit. They called it the heart bill. They knew about his heart claim. It wasn't, and it also has to be with the employing agency. But I guess you're saying that if he had notified his employer about a claim for unemployment benefits?
Say he lost work, unlike your client, but somebody that was out of work, would that suffice as a claim for benefits?
No, I don't. I think that's different here, because it was a benefit under the heart bill, their collective bargaining agreement heart bill. He was paid lost wages. He had no idea that there's a difference between the heart-lung statute, which is also called the heart-lung bill, and the collective bargaining agreement heart bill. And a lot of the employer representatives didn't know the difference either. They've since fixed the system where this doesn't happen. Like they no longer provide the benefits separate under the separate bills. But he did everything right.
If the incident would have been properly reported to risk management, that still wouldn't have been a claim for benefits, right?
Well, if it had been properly submitted to risk management, then he would have. It's a claim for benefits, yes, because it's under the case law, which I was about to get into, under Scherer versus Volusia County. A claim for benefits isn't only the filing of a PFB, it's also another assertion of rights or the vesting of rights under Chapter 440. If a notice of injury had been filed and it had been reported to risk management, he most certainly would have had a vesting of rights under Chapter 440, but that didn't happen here. But the term claim for benefits absolutely should be interpreted more broadly than just a work comp claim or a petition for benefits. And again, the Scherer case stands for that proposition. It says, and I quote, that once an industrial injury occurs, the term claim refers not only to a PFB or other assertion of rights, but also to the vesting of rights under Chapter 440. So it's not simply a PFB or work comp claim as the judge found here. This is supported by the statute itself, by 112.18 sub 1b. If you look at that provision, that statutory subsection, there's 4 different subsections within there. The term workers' compensation claim is used 3 times in that subsection, but it's not used in the provision that we're speaking of. Instead of using the term workers' compensation claim, they use the term claim for benefits. So under elementary principles of statutory construction, if the legislature intended this to only have to apply to a work comp claim, they would have said that. They wouldn't have said claim for benefits. Here again, his arrhythmia was diagnosed during a wellness exam provided by the employer. It was reported to his supervisor. That's uncontroverted. The judge found it in his order. Lieutenant Barfield reported that she knew of the injury. She sent it up the ladder. Nurse Shaw, the city's occupational health nurse, made a claim, and he used that language, under the CBA, the Collective Bargaining Agreement Hart Bill. And the claimant was paid 3 weeks of lost wages. That's undisputed. Nurse Shaw testified to that. The claimant testified to that. And the attendance logs show that he received HRT time, which Nurse Shaw explained was heart hypertension leave time. So the claimant did make a claim for benefits within 180 days and was actually paid lost wages. Again, the city never filed a notice of injury or notified risk management like it was supposed to, and we've got undisputed adjuster testimony saying that was a mistake. They should have done that, and they did not. So there was an assertion of rights. There was an assertion of a right to lost wage benefits. And there was a vesting of rights under Chapter 440 that should have occurred if the right action had been taken, which wasn't taken per the adjuster's own admission.
Now, so it seems to me that, one reason we have the 180-day limitation, which doesn't exist for other forms of compensation, is because of the presumption itself. Because the burden is going to be on the agency to prove causation, employment causation.
Yeah.
Is there anything about how this was done that would have put this agency on notice that they had the burden to establish that kind of causation? In other words, I didn't get the impression from the agreement, the Hart Bill, as it's called, that there was any kind of a presumption issue that had to be resolved. I mean, it seems that that's the purpose of the 180-day rule, and I'm not sure if the agency was ever put on proper notice.
Well, I mean, it also doesn't apply to firefighters, so that's interesting that it only applies to corrections and law enforcement in this subsection. But, as the agency, as the employer, and this kind of gets into the estoppel argument. So really, we've got 2 arguments here. The first is that he did file a claim for benefits. A claim for benefits is more broad than simply just a work comp claim or a petition. And what he did was an assertion of rights that should equate to a claim. But on the other hand, even if this court didn't agree there, then the city should be estopped in this case because by their own admission, they didn't do what they were supposed to do. It's hard to go back and say what would have happened, but they acknowledge that they should have filed a notice of injury and should have reported it to risk management, and that didn't happen. And to now come back and say, well, we're prejudiced because if we had known, we could have, come up with a rebuttal defense, which I guess is what you're saying. They would have had more time 7 years ago because this happened. The case was brought in 2018 and the injury happened in 2011. They can't go back and say that because they didn't do what they were supposed to do. This is estoppel by omission.
Does estoppel apply to this presumption? Because we're not talking about a statute of limitations, but we're talking about just the application of the heart-lung presumption to a law enforcement officer. Does estoppel apply to grant your client the presumption?
Estoppel would apply to keep the employer carrier from asserting that the 180-day limitation is a bar in this case. And that's estoppel by omission. And in the Gauthier case, the court went into detail about the self-executing nature of the statute, that it's an employer-monitored system, and that an employer is under a continuing obligation, once it has knowledge of an injury, to place needed benefits into the hands of the injured worker. In that case, the court held that the employer carrier failed to act when it was under a duty to do so, and that the claimant was misled to her detriment by that omission. That's exactly what happened here. The claimant was misled to his detriment by the omission of the employer carrier for not acting when they were supposed to act. And it's not disputed that they didn't act when they were supposed to act. I mean, the adjuster's testimony is uncontroverted that someone dropped the ball, a notice of injury should have been filed, and it should have been sent to risk management. It wasn't.
Can you mislead somebody by an omission? I mean, he wasn't informed. And
Yes.
had he been informed, probably there would have been a proper claim. But can you mislead somebody by not, I mean, by not affirmatively making a
Yes, under the
statement?
Gauthier case, you absolutely can. That's what the holding of the case said. It says, again, and this is a direct quote, the court, they held in that case that the employer carrier failed to act when it was under a duty to do so, and that claimant was misled to her detriment by that omission. So absolutely, you can be misled by an omission. It doesn't have to be a proactive statement that misleads the claimant, and it doesn't have to be intentional. And that's what the court found here. That was the error, because the judge held that there was no estoppel because there was not any information provided by the EC to the claimant upon which he relied. But under the Gauthier case, that's not what's required. There can absolutely be estoppel by omission, and that's exactly what occurred here. Here, the employer carrier failed to act when it was under a duty to act, and the claimant was misled to his detriment by that omission. Again, the adjuster testified without controvert that the employer carrier made a mistake by not filing the notice of injury and not sending the case to risk management like it was supposed to.
Not filing the notice of injury is different than establishing a duty. It seems to me omission can only result in estoppel when there is a pretty well-defined duty to act that they omitted to do.
Well, they have
So-
a duty to file a notice of injury. They're under a duty to do that by the adjuster's own admission. Am I not understanding what you're asking?
Maybe I just don't understand the issue, but what kind of to me, the omission has to be a duty to the officer, not a duty to do something. A
Well, a
duty to
duty
the
to
officer.
file- okay, so-
In other words, like they had a duty to notify.
Yes,
That would be
okay,
a good
and
example.
so, and maybe I'm being too broad by saying to file the notice of injury. When you file a notice of injury, that also includes sending notice to the employee of his rights. That's inherent in.
So you're saying they do have an actual duty to notify?
Yes, they
the
need to
officer.
send him the
Okay.
brochure, the workers' comp brochure, and the notice of injury is what triggers the notification. That didn't happen in this case. He wasn't sent in 2011 following this accident. None of the normal things that happen in a case happened. And the adjuster stated on the record that, we're not disputing, like it's not that they're saying she didn't say it and we said we did. There's no factual dispute that happened, that she admitted this should have happened and it did not. I mean, what are we encouraging here? I mean, what's the policy that can happen?
You're well into your rebuttal time.
Yes, let me I'll just wrap up. So we're encouraging employers to ignore heart-lung injuries that they know about, they have actual knowledge of, and wait until a claimant retires, when the claimant here did everything right. And he didn't know about the heart-lung statute. He found out about it many years later at the FOP meeting. He notified his supervisor just like he was supposed to do. I mean, such a result thwarts the public policy. And there's a strong public policy embodied in the heart-lung statute itself. There's also a public policy in 440, self-executing employer-monitored system. So what we would say is that the court should reverse based on that, and I will reserve the rest of my time for rebuttal. Thank you.
May it please the court. My name is Tom Portuello. I represent the appellee, the Jacksonville Sheriff's Office, and City of Jacksonville Risk Management. And we feel that the JCC's order should be affirmed for a number of reasons. But first, let me point out a couple things or arguments made by the appellant that if you accept right out the gate, sort of takes us off on a wrong direction according to the facts in this case. Number one, they're saying that there was timely notice of injury. The JCC made no such finding. What he found was that the claimant provided to his supervisor notice of a medical event. That's what he found. And when you look at the supervisor's testimony, and she said this word, she said, I'm clear on this, that had he reported an injury that occurred on the job or was related to employment, she would have completed a first report of injury, like she had with this particular claimant many times. Another point that they take that we strongly disagree with is a statement even made today that this claimant didn't know that he had the heart presumption under workers' compensation available to him at the time of the 2011 medical event. That's simply not true. This claimant had a prior heart claim under workers' compensation with this employer utilizing the statutory presumption of Florida Statute Section 112.18, where the claimant was provided with medical benefits. The claimant was provided with informational brochure, first report of injury, and knowledge of his rights and responsibilities on workers' compensation. The record reflects, and you'll see in the record, at least 7 first reports of injury involving this claimant. So there's a lot of facts that come out of the gate here that I think take us in a wrong direction. So there was no notice of a workers' compensation injury. There was a medical event. I don't think it's proper that the carrier be forced to assume that every medical event, even a heart condition, occurred on the job. And so the supervisor did not report it as a
Do they have to,
work-related
since there's a presumption?
Well, the presumption has to apply. Elements have to be met. So I would say definitely no. No. And I think that's, however, I think that's what the adjuster responded to at the time of her testimony, under the hypothetical situation that this medical event is related to work activities. But there are a number of steps you get before the presumption applies. It doesn't apply right out of the gate, and the supervisor is certainly not going to be aware of that. So hypothetically, though, even if notice of injury was provided, which it was not, does notice constitute a claim to toll the 180 days? And it's our position that it does not. A claim must be made. So the statute is clear, its meaning is plain. It must be a claim, not notice of injury. And it must be made. It must be asserted. And that's what the judge looked for. He didn't look for only a written claim or a filed petition. He looked for any actions by the claimant that could be construed as an assertion for workers' compensation benefits.
If notice was given, then the employer has an obligation to send a brochure to the potential claimant, right? And that didn't occur here. Is there any remedy? Does that play into the estoppel or anything along those lines when the employer allegedly failed its duties there?
Yes, sir. And let me jump to the estoppel argument. He had received brochures previously and received one for his heart claim previously. He had actual notice of his rights and responsibilities under workers' compensation, which would prevent the estoppel. He had first reports of injuries. But what's also missing in the evidence is any relationship between the information provided in the brochure and a first report of injury that the claimant would have relied on to his detriment. There's nothing in there that says had he received the first report of injury, he still would have filed the claim. Nothing in there that says had he received the booklet, he still would have filed a claim. And consistent with that, his prior heart claim with this employer, he ceased pursuing that, just like he ceased pursuing this claim. I mean, he even had the benefit of counsel in this claim in May of 2016. The benefit of counsel, but did not file a petition until May 2017. He was not pursuing his workers' compensation claim, whether it be his first heart claim or his second heart claim. He let the statute run on the first one, and it wasn't until almost 7 years later that the carrier gets notice of injury and gets a claim for the 2011 incident and has to somehow put together evidence from 6 or 7 years ago to rebut these claimants' assertions. I think in an everyday situation that would be terribly unfair to the carrier to have to go back so many years. But in this case, they did it. They did it in this case, and they still got the testimony from the supervisor to say no notice of injury was filed because we didn't know it was on the workers' comp side of things. So on appeal, I hear for the first time, and I tried this case at the trial level, I hear for the first time that the word claim for benefits now means not a claim for workers' compensation benefits, but a claim for other types of benefits as well, such as benefits under the union contract agreement, which is not in evidence. So all we have is lay testimony of people going back 6 or 7 years and telling us what they think was in this contract, and they're not even sure when it applied. Did it apply in 2011, or was it changed before 2011? What was the internal log, attendance log saying? That's what we're going back. That internal attendance logs, first of all, it's not a claim for benefits. Second of all, it was generated after I contacted this nurse in May 2017. He testified to that. It wasn't even generated before that. And if it does establish payments under the union contract, it's certainly our position that that is not a claim for benefits under workers' compensation. And that's important because Rule 60Q of the Workers' Compensation Administrative Rules defines claim as assertion of benefits under 440. It has to be an assertion of right under 440. The Scherer decision that opposing counsel mentioned talks about vesting of rights under 440, not under a union contract. So even if there was notice of injury, which there was not, even if there was a claim outside of workers' compensation, and I'm going to argue that there was not in a moment, I still don't think the 180 days are told. And I say there was not even a claim for the union contract because once you look at that testimony, it's not specific, it's terribly vague. He had a claim for a heart claim, a prior one that was definitely under the union years. And it's unsure whether these witnesses going back 6 or 7 years and now beyond that to address his initial heart claim, it's unclear whether they're talking about the initial heart claim or they're talking about this 2011 medical event. The same thing with the supervisor when she talks about, and you'll even see it, at one point in this case they argue that there was a supervisor's note of the 2011 injury on the job. But when we question the nurse, he says, no, that never happened. It was on the prior heart claim. So I think this judge did a very appropriate job. He looked at the entire evidence and decided not only whether there was a written claim, a filed claim, but was there any actions by the claimant that could be considered as an assertion of workers' compensation benefits. And to argue that an assertion of something other than workers' compensation benefits establishes a claim to toll the 180, number one, it wasn't raised at the appellate level. It's very unfair to us. We don't have evidence on that issue because it wasn't raised. Number two, it makes no sense. It would completely evaporate the statute to begin with. You'd go back and look at any types of claims, on unemployment claims, any other type of claims you want to say that the 180-day rule is told. It makes no sense, and also it violates what is the plain and clear meaning of the statute, the rule, 60Q rule, and this court's determination in the Scherer claim and in the Scherer decision. That's it. That's all I have.
Thank you.
I would just like to point out that the 2003 claim was also under the heart bill and not under the heart-lung statute. The claimant testified without controversy that he didn't know about the heart-lung statute until the FOP meeting. And whether there was a delay after that goes to the statute of limitations, which isn't at issue before this court right now. If this court reverses and remands, then there might be a statute of limitations issue in the lower court, but that's not before this court now. And this issue of what the construction of the term claim for benefits mean was argued at length at the trial below. In the pre-trial memos at the trial, and we got page 35 of the record, the transcript at page 95 through 102, 118 through 122, even the EC was arguing it at 104 and 105 of the trial below. It's not necessary that an appellant give every single legal basis or support for their argument in order to preserve it for review. The judge's holding centered on the construction of that term. And at trial, counsel for the claimant argued that it should be more broad than simply a work comp claim. It should include an assertion of rights, whether under 440 or any assertion of rights. And what he was arguing was that this assertion of rights under the Hart Bill should act as a claim for benefits. And the vagueness as to the depositions, the employer carrier didn't object, move to strike, or otherwise dispute nor Shaw or Lieutenant Barfield's testimony at trial. It's self-serving to bring it up now. And the judge found by competent substantial evidence supports that the injury was reported, but the employer carrier didn't do what they were supposed to do. And for those reasons, we would ask the court to reverse the holding of the JCC and to remand for further proceedings consistent therewith.
All right. Thank you both for your arguments. We have no other cases to come before us, so we are adjourned.
All rise.